how do they do it? This is not the same as going and seizing a home, seizing a car, seizing a watch or a piece of jewelry. The quantifiable dollar amount of an alleged fraud or an alleged scheme is what controls how much federal interest. How hard is the government going to do to investigate and prosecute this case or bring charges? Hey everyone, David Tarras here, head of the federal and white collar practice at the Rossen Law Firm. So in previous videos, we've talked about the process of forfeiture, more generally speaking. Today, we're going to talk about what is a super hot button issue, which is the forfeiture of cryptocurrency. At the Rossen Law Firm, we've been involved in many of the emerging prosecutions regarding cryptocurrency, usually as it relates to financial schemes involving certain companies. There's been very high profile ones in the news, and certain of them that our firm has been a part of as well. And a lot of the cryptocurrency aspect of these cases, you do have to hire experts and lawyers like us at the Federal Criminal Defense Attorney who have experience in defending the allegations regarding fraud that may be related to certain cryptocurrency exchanges, regardless of what cryptocurrency that we're seeing. Of course, now what we're seeing mostly is involving Bitcoin and Ethereum. Bitcoin more than anything because its value is skyrocketing, or at the moment it's somewhat stable, but we always know what can happen. And we certainly know, having expertise in this area in crypto, what can happen. And we see the SEC, the Security Exchange Commission, and their efforts every day to try and increase regulation regarding Bitcoin and Ethereum. So far, they've had difficulty with it, but that doesn't mean that criminal prosecutors from the Department of Justice and the U.S. Attorney's Office can't try and bring criminal indictments as it relates to cryptocurrency frauds, whether that be in the form of them alleging a Ponzi scheme involving cryptocurrency or other frauds or pyramid schemes. They love to use these fancy terms in their indictments and in their prosecutions. But really, there are a lot of ways to defend these cases. What we're talking about and focusing on today is, so how does the government go and actually, if they're able to obtain a conviction, or if they're not, but they're seeking a civil forfeiture of cryptocurrency, how do they do it? This is not the same as going and seizing a home, seizing a car, seizing a watch or a piece of jewelry. With cryptocurrency, the ability of the government to actually go and do this is extremely nuanced, but they're learning. They have specific divisions starting from main justice in Washington, D.C., and now several different units, including the Southern District of New York, have divisions and agents, task force devoted strictly to investigating, finding cryptocurrency that may, or they believe, is involved in a financial fraud scheme, such as wire fraud or securities fraud, two of the bigger ones that we see in these cryptocurrency styled indictments, and trying to recover that money. There are thousands of different types of cryptocurrency. As said before, their big focus is on the ones that contain the most dollar value, which is Bitcoin and Ethereum. But it's not exclusive to these. So a lot of very complex legal implications are in play here when it comes to what can the government seize and how do they go about seizing it and how do we stop it. By its very nature, one of the most attractive and the appeal of cryptocurrency is that it is supposed to be a more protective and a more private form of transaction. At the same time, it also does have a lot of transparency. These blockchains, the Bitcoin and the Ethereum scans and blockchains, are available online for the public to see. There are certain types of transactions with cryptocurrency that do involve more private transactions on certain sites for very large amounts of Bitcoin or other cryptocurrencies. But in general, we're talking about blockchain tracing. Now, the government and the FBI and their crypto task force will have tools that they use in attempting to follow illicit funds through a variety of transactions, ultimately ending up in cryptocurrency, and then do what's known as blockchain tracing and other forms of crypto digital asset tracing to literally trace these funds to our client or to other individuals associated with our client in a conspiracy in attempt to establish the amount of funds that may have been involved in the fraud, digital assets that may have been involved in the fraud. We at the Rossen Law Firm have a team of experts who have the same exact tools and regularly contract with these experts in these cases who have the same tools and better than the government. A very primary tool being known as Chainalysis, which can track cryptocurrencies to wallets that maybe we already know are associated with an individual, or we don't yet know are associated, and we need to, like the government does, request an investigative subpoena to determine who that wallet belongs to. But what the government is doing is they are most commonly doing a tracing, and then they are sending a subpoena to an exchange, whether it be Kraken, different common, all the different exchanges that are out there right now and regularly used for the transport and the transfer of cryptocurrencies. And they're requesting subpoenas to get the name behind the key, behind the wallet. And another issue is that there's all different kinds of wallets. There are hard wallets, there are cold storage wallets, there are different wallets that exist within these structures, within individuals' crypto holdings that the government is learning more about and taking significant efforts to try and uncover and seize as part of whether it may be their efforts towards getting restitution in a cryptocurrency related scheme. If they're able to secure a conviction, our job is to stop that. Or for forfeiture as well, and to forfeit unlawfully gained proceeds that are found in wallets that the government can trace down. There are many high-profile examples of the government being able to do this, but it's not as easy as the Department of Justice and their fancy blogs and news articles would make you think. It has to be challenged and examined by your own expert, and that's what we do in every case here at the Rossen Law Firm. There are so many nuances we could talk about and complexities of this. One of the most important one, and why it's so important to hire an attorney like the attorneys at the Rossen Law Firm who have specific experience in cases involving cryptocurrency and other digital assets, is because of the valuation. Valuation, or what's more commonly known as loss value, or simply the quantifiable dollar amount of an alleged fraud or an alleged scheme, is what controls how much federal interest, how hard is the government going to do to investigate and prosecute this case or bring charges, how hard is the government going to go, how much resources are they going to use in determining whether or not they're going to trace these assets, get in there, follow these funds, and ultimately try and seize these funds in order to make a recovery for the government. And when it comes to valuation, this is a whole new ballgame when it comes to cryptocurrency, because a lot of the cryptocurrency cases that we're seeing are allegations from 2016, 2017, 2018, 2019, and sooner in time, but even going back to that time when the value of Bitcoin, when the value of Ethereum was substantially less than it is now. So we're seeing the government, what they're going to do is they might take a 2017 case and say, allege that this amount of Bitcoin was stolen, and as of Today's date, as of June 2024, the loss value in this case, based on the number of Bitcoins that were allegedly stolen or diverted or the result of fraud or laundered, is now $450 million or $700 million or $2 billion. I mean, astronomical numbers, but what was it in 2016? Was it $1 billion? No. Absolutely not. Depending on the coin, if we're talking about Bitcoin, sometimes it's as much as 99% lower than what the government is alleging at today's date based on the time period. Now, it's not always that dramatic, but certainly substantially lower. And unsurprisingly, the government is bringing these cases now. Why? Rhetorical question, because Bitcoin is booming. Was it so fun to bring a Bitcoin case back in 2018 or 2017? They could have done it, but do they want the $7 million recovery or the $450 million recovery? Of course, that's what they want. That's what the headlines are, and that's what their efforts are based on. So challenging the valuation directly correlates to getting the best result for our client, and we have a lot of experience in doing that. We also have a lot of experience in trying to prevent, not mask, not hide anything, but to prevent the minimal amount or prevent the maximum amount that the government is going to be able to seize as part of a forfeiture or efforts to recover funds in a cryptocurrency scenario. One of the things, for example, that we'll do is we'll have our own top experts go through their own tracing and look to find if there was any dormant Bitcoin in any of the wallets that have been associated with our client or with this conspiracy. It's not uncommon that there are dormant funds. There may be 9 to 12 Bitcoin sitting in account that in 2017, and that still remains in 2017, might not have been a big deal, but in 2024 is a significant amount of money. We're talking about millions of dollars here with the current value of these digital assets, of these cryptocurrencies. So if we're in a posture where we're just trying to, let's say, not go to trial, but to limit our client's potential exposure and put our client in the best position to receive a sentence that doesn't involve incarceration or absolute minimal incarceration, if any, then doing that and doing a full tracing analysis is extremely important. So it's never too soon, even if you haven't been charged yet, but if you have perhaps received any sort of subpoena or notice from any agency that they are looking into your accounts as it relates to cryptocurrency, and you've received a subpoena or a demand to say whether or not a certain wallet belongs to you, even if you haven't been charged, it's definitely the time, if not even sooner, to reach out to the Rossen Law Firm and our experienced attorneys in fighting against cryptocurrency-related allegations that the Department of Justice brings so that we can get you the best possible outcome in the case and walk you through the intricacies and the very dense technical material that's involved in defending a case that involves cryptocurrency and the forfeiture or seizure of cryptocurrency. So if you find that you're in this situation or you just want to seek legal advice regarding cryptocurrency itself, please do not hesitate to reach out to us at the Rossen Law Firm as soon as possible. Thank you.